not sure about Academia Sinica, but it's possible, so you can check the contracts. So this particular patent was originally assigned to Hewlett-Packard, which is, I know them as printers, they also do computer things. So it was originally assigned by the inventors to Hewlett-Packard, and then later on assigned again to someone else, and then finally it was assigned to Lumileds Lighting, which is Philips, it's Philips' company. And Philips is one of the big 5 LED companies. And this particular patent is one of the main patents that has been litigated in courts against Taiwanese companies particularly. So here are some more pictures of the drawings that will go into a patent. This one is interesting because it's prior art. This is basically, when we write papers and at the end of the paper you put your references, this is basically a reference. And in putting it in the patent application, this suggests that the application has to explain why they're different or newer or better than this particular prior art. Okay, so the two most important parts, however, are the description of the invention and the claims. The description section can be seen as a result of internal communication or internal claim making. And the claims section can be seen as a result of external claim making. So it's in these two portions that we see that even in the case of an invention that only has a single inventor, a patent itself is actually created socially in the negotiations between people. So more so than tangible property, this is not just a matter of a dispute over the rights to an already delineated set of wealth, nor is it even something similar to disputes over the boundaries of where a land claim ends. Instead, these negotiations actually are what create the thing to be owned itself. So who writes the description of the technology in a patent? You might think it's the inventors. Actually, it's generally not. These are usually written by patent engineers. These are people who specialize in intellectual property, either in the company or at an external agency, and who generally have an earlier background in the technology. So even though the patent engineer actually writes the patent, he does so only after interviewing the inventor to figure out what exactly has been invented. So this collaborative discussion often takes multiple rounds, as the inventor's idea of what has been invented has to be reconciled with the patent engineer's knowledge of what has previously already been claimed. What land, if you think of it in terms of land, what land is already claimed and what part might be open still. So often only a piece of the original idea will make it in as part of the technology that will be new enough in order to merit protection. Sometimes, in other cases, the original idea will be split into multiple patent applications and applied for separately. So the business and R&D folks I've talked to suggested a further complication to the writing of this description that plays into these negotiations. They emphasize so far at least when I've talked to them, that there's a need for some degree of craftiness, or a little bit of jianjia in patents. You have to both describe the invention, but you also can't describe it too well. You should reveal only enough knowledge so as to be granted the patent, but not enough for others to immediately be able to use it. Or perhaps you change the wording on it. So instead of saying a light-emitting diode, which is LED, I might say a light-emitting device, or an optoelectronic device. And so even using keywords, there are some patents that you might not pick up. So the final patent, therefore, is neither the technology itself nor the original idea. Rather, it's a hybrid between the inventor's idea of the technology and the patent engineer's view of what would be the broadest patentable description of it. In other words, when the intangible idea of a patent is transformed into tangible patent form, it shifts from something that's focused on solving an engineering problem, in this case at least, to legal language directed towards convincing the Patent and Trademark Office or any judge or jury who might review it that it's new and novel and worthy of a patent. In these internal negotiations, it's therefore not the rights themselves that are negotiated. Again, it's the very content of the property itself. Even in IP, though, this is a unique situation to patents. This kind of transformation just does not happen in copyrights or trademarks. So the claims. The writing of the claims, on the other hand, is a result of a more adversarial negotiation with people external to the company. So crafting the claims is an art of persuasion, or argument, rather than creation or engineering. It's perhaps the most essential part of the patent, as it's the claims which determine the size and the scope of the technological area that's going to be protected by the ownership rights. The claim section is first written by the patent engineer again, and then it's sent by an attorney to the PTO, the Patent and Trademark Office, I'm just going to say PTO now, for examination. So this is the first claim that the company makes. It stakes out its claim to rights over a particular kind of technology in a particular area. At the PTO, the patent examiner does a search of patents, academic papers, products, and anything else she can find in order to find previous examples of public knowledge that would make this, quote, new invention actually obvious, and therefore not patentable. The examiner sends back the prior art or references that she found back to the patent engineer, rejecting the claims as they were written, saying this is not patentable, I reject. The patent engineer then works with the inventor in order to rework the claims, changing some wording, finding some way to overcome these objections, and then sends it back. So this back and forth of claiming and counterclaiming generally continues 2 or more times before the patent engineer's company either gives up or the examiner gives up and agrees the invention is new and grants a patent. So throughout this process, the patent engineer wants to make the claims as broad as possible in order to make the patent stronger. He wants to be able to exclude more of his competitors' potential options to work around it. The patent examiner, on the other hand, seeks to represent the public by preventing patents on already public knowledge and by making the patent claims as narrow as possible. At each step, the scope of the claims and the wording of them is tweaked. And in effect, it's out of this process of communication that the invention, or inventive step in patent terminology, that actually can be claimed emerges as separate from the technology and separate from the original idea of the inventors. It's this inventive step that can be owned, and it's this inventive step that can be excluded, that others can be excluded from making, using, importing, or selling. So these are just 2 particular examples of the kinds of communication that go into making a patent. There's also internal reviews that decide which patents are worth patenting from the company's standpoint. And there's also the fact that once you have a patent and you want to enforce it, you have to take it to a court of law. And the court of law, again, will have to decide exactly how they're going to interpret the claim. So given the possibility that a judge or a jury will read the wording in a patent slightly differently than the patent engineer had intended, it's nearly impossible to guarantee that a patent actually covers what you think it covers until it's been successfully held up in court, or until it's been successfully fought out in multiple out-of-court settlements. So I think all of these examples show ways that the patent as communication paradigm helps us to better understand a patent as a process that really is never finished or determined until it wins or loses in court. And the vast majority of patents never make it to court. So where then does the communication idea break down? So until now I've been dealing with patents as standalone entities. But actually, as you can tell from the strategies of Taiwanese companies, this is very rarely the case. Often their patents are put together in defensive patent portfolios, for instance. So before beginning this project, I had an idea of a patent as somehow standing in on the one side for a technology or idea, and on the other side for a product. It should be clear, I think, now that there's no one-to-one correspondence between technology, ideas, and patents. And there's also none for products and patents. In effect, the best situation for a company is to have a line of products protected by a line of multiple overlapping patents. So, one of the problems that I came up in starting my research is trying to figure out which patents are important and which patents are just kind of junk patents. And so I decided I would try to ask people and try to get a list of their top 10 patents and then top 10 technologies, and then I could compare them across multiple interviews to find ones that overlapped, and chances would be that those are the important ones. The problem is that although everybody was interested in